Most important thing, and the thing I'm going to talk to you about in this video, is considering intellectual property. Now at the university, if you breach intellectual property laws within the UK, that's a form of academic dishonesty and can be prosecuted under the university academic dishonesty rules. Worst case scenario, you get thrown out of university for that. So we really don't want this to happen. In order to prevent that, I thought it was worth making a video to you to explain exactly what those rules are and what the law is within the UK. The main law we're going to be concerned with is copyright law. You must not breach copyright in this module. In particular, you must be able to say where all graphics and audio assets have come from and show that you have the right to use them. That does not mean that you can't use any graphics that have a license that say you must accredit who created this graphic. What it means is if you do use any graphics like that, you must make sure you credit them, both within the code and, more importantly, actually within gameplay itself. So if the person sees the video you're going to create of your game and sees if you use the graphics, it's really clear to them that you've also correctly attributed them. Copyright law under the UK relates to literary works. That is anything that's actually written in text. So things like song lyrics, manuscripts, manuals for a piece of software fall under literary law. Quite interesting, I think computer programs themselves, because they're written out as text, do fall under literary law. We've also got dramatic, so plays, dances, anything for somebody who's actually on a stage tend to fall under dramatic copyright law. Musical, recordings and the score are both fall under musical law. Artistic, that's photography, painting, sculptures, architectures, drawings. Also things like maps, logos, anything that you would think of as a drawing falls under artistic law. Sound recordings, which actually may be themselves recordings of other copyright works, i.e. musical or literacy, but the actual recording falls under copyright. As an example, if the London Symphony Orchestra plays a piece of music that is still under copyright law, maybe it's a score to Jaws or something like that, and then they release that as a CD, that sound recording on a CD is under copyright law because they have got the right to play the musical score or the piece of Jaws. So in that case, the London Symphony Orchestra has the right to that recording. Other thing that's under copyright law in the UK is film. So that includes video footage, films, broadcast and cable programmes. It actually has recently been shown to also include cutscenes, so it's quite interesting that it's got that link to games. How long does copyright last for? Well, for literary, dramatic, musical or artistic works, it's 70 years from the death of the author. Okay. For sound recordings and broadcasts, it was 50 years, it's just become 70 years. This is often actually known as the Mickey Mouse effect. So Disney is really concerned about Mickey Mouse coming out of copyright because you can imagine the sort of things you might find if Mickey Mouse is no longer in copyright. So copyright in the UK and the US keeps extending to make sure that Mickey Mouse never leaves copyright. Films are in copyright from 70 years from the end of the year the film was first made available. So it's not finished filming, it's first made available. And currently broadcast and cable programmes, so television basically is 50 years copyright on that. So what's a breach? How do you know if you've breached copyright? Well, it's an offence to perform any of the following acts without the consent of the owner. The one that most people think of when they think of copyright law is copying the work. If you copy the image, the piece of music, the piece of literary work, then that is completely a breach and against the law. It's also illegal to rent, lend or issue copies of the work to the public, which is quite interesting. Things like libraries actually have special licenses to be allowed to lend out copyright work. It's illegal to perform or broadcast or show the work in public. And it's also illegal to adapt the work. Now, the adapt the work is the one that causes the most concern and is the one that's really quite more difficult to define. So, what does this mean for computer games? Okay, it is quite clearly illegal to make an unauthorised copy of a game and sell it. If you do that, you're completely breaking the law and there's no two ways about it. However, making a backup copy of a game you own a license to is not an infringement. As long as you keep the original game, you're actually allowed to make a backup. If you were then to distribute that game, that would be an infringement. Also, copying significant elements of source code of the game would be an infringement even if the game looks completely different. This comes down to the fact that code is copyright under literary law. So if you copy lots of lines of code, that is an infringement of the law. Some things are a bit more interesting. Copying major elements of the graphical user interface, for example, having exactly the same heads-up display as another game, may be an infringement, but so far it hasn't been. So far that has never been held up by the courts. Making a game that reuses a general game idea that is already copyrighted is also not an infringement. You can use a game mechanic that somebody else has already come up with. However, copying any art or audio directly from a game is an infringement. You must not copy art or audio directly from any game. There's another side to intellectual property law. So you're probably thinking, okay, how do I not breach this in the module? The thing to remember is that intellectual property law will also protect you. It's a way of making sure that nobody can copy the game you're making. In this case, there's really three kinds of intellectual property. There's copyright, patent and design, and trademark falls under design. So how do you get copyright? So you automatically get copyright protection when you create an original literary work, dramatical music, artistic work, and that includes illustration and photography. A non-literary work, so software, web content and databases, sound and music recording, a film and television recording, a broadcast or television program or radio program. And also you get copyright on the layout of published editions of written dramatic or musical works. Okay. You can mark your work with the copyright symbol, C, where you name and the year of creation. However, whether you mark the work or not doesn't have the effect on the level of protection you have. It's a way of you showing that you consider this work copyright and to be your copyright, and a way of indicating somebody that if they copy this, they might be breaching your copyright. It doesn't actually give you any more protection. Your work could also be copyrighted in other countries through international agreements such as the Berne Convention. In most countries, copyright lasts a minimum of life plus 50 years for most type of written and dramatic and artistic work, and at least 25 years for photographs and for graphics. It can be different for other types of work. So what I'm saying here is, remember, the main thing I'm talking about is UK copyright, and it may be different in other countries, and it may be different in the country you're from if you're not from the UK. You can also register the look of a product you're selling to stop people copying or stealing it. The look of your design includes the appearance, the physical shape, the configuration of her different parts linked together, and the decoration. For example, if you wanted to register the design of a game, what you would do is you would just take one level of the game, which had all the characters on it, and you would protect that design. Patents we'll get to in a second. If you want to have registered design, you have to actually go about doing this. You have to take it to the government and say, I want to register this design. It does protect any aspect of your design, so both the product shape and decoration. It gives you exclusive rights to use that design for 25 years, and it makes taking legal action and infringement a lot more straightforward than just copywriting does, because it means that you've actually got a piece of paper that says you own this. Once registered, you can display your registration number on your design. You have to apply to register design with the government, as I said. It costs £50 for one design, and if this is something that interests you, there's a link there for further details. You can also have a trademark. People tend to trademark names, or in fact logos. So for example, McDonald's, definitely trademark, and the golden M is their logo, and that's trademark. It might be that you want to trademark the name of your game, and that would cost £170. Patent is a completely different type of IP, which doesn't usually relate to games. With a patent, you must have a new invention, something that nobody's ever invented before. So I suppose technically you might be able to patent something like a game mechanic. However, it's unlikely. The other thing to note about patents is they cost £230, and that's without any legal fees. So they really are a very expensive option. But I thought it was worth mentioning them here because they are a type of IP.